In this video, I want to talk about what happens after a baby is born via surrogacy. And the answer actually depends on where the baby is born. So in Ontario, we have one set of laws. In other provinces across Canada, there's different laws. And of course, around the world, other systems. So in Ontario, there's actually two different paths that parents can take after their child is born via surrogacy. So as long as the surrogate delivers in Ontario, even if the intended parents are from another jurisdiction, this is what will happen. So path number one, which is what happens most of the time, we refer to it as a statutory declaration. So it's actually fairly simple. It involves some paperwork, basically, that has to get signed after the baby is born. Intended parents can sign the paperwork at any time. Surrogates must wait until at least 7 days after the birth to sign the paperwork, also referred to as a consent or a declaration. That paperwork then has to get sent off to the government. Birth registration can happen after birth certificate is in hand, passports can be applied for, and so forth. So it's fairly streamlined relative to the other option, which is referred to as a declaration of parentage. What that means is going to court. And anytime people are going to court, even if they agree, it's still a lot of work. There's a lot to draft, a lot to do. So it takes time, it takes money, and the end result is a court order declaring the intended parents to be the parents and declaring the surrogate not to be a parent. So those are two different options. Now, why would anybody go the declaration of parentage route when there's this other route that's faster and cheaper? So there are a few reasons why. This faster, cheaper route, the statutory declaration, is only an option if a few criteria are met. There has to be a surrogacy agreement. The parties have to receive independent legal advice, which means the surrogate has her own lawyer separate from the lawyers advising the intended parents. And the surrogacy agreement has to be signed before the embryo transfer, so before she's actually pregnant. If those things happen, then generally, if the birth happens in Ontario, statutory declaration is the way to go for most people. There are some other reasons why going to court may be necessary. In the unlikely event a surrogate became incapacitated and couldn't sign the paperwork, or she died, or she couldn't be found. If she can't sign the paperwork, going to court is certainly a plan B. And the other reason would be based on where the intended parents are from. So let's say they're from another country outside Canada, where the rules around surrogacy are very different. They might need specific language in a court order in order to return to their home country and be recognized as parents. And if that's the case, it might be that going the court route and getting a court order with very specific legal language is quite important to them based on legal advice they have received from a lawyer in their home country, based on surrogacy laws or immigration rules, whatever the case may be. So in some cases, it might actually be necessary or quite helpful that they go to court. But in the vast majority of cases, this statutory declaration route is faster, cheaper, and kind of a no-brainer for the majority of people pursuing surrogacy where the baby is born in Ontario. So that's it for this video. I hope you learned something new, and I'll see you in the next one.